So Dana, I've been working with a buyer. We searched and searched and searched, finally found a home, had the inspection done, sent the contract to the closing attorney and to the lender, and we are in our due diligence period. We're negotiating back and forth with the seller. Finally sent, rather than asking them to do repairs, requested they come down in sale price. And all of a sudden, the seller terminates the contract. Can they do that? Hi, everybody. Dana Sparks, broker of Maximum One Greater Atlanta. And the answer is, well, yes, obviously they can because they just did. The better question is, what are the consequences of a seller terminating a contract during the buyer's due diligence period? Yes, I said that specifically in that way. A due diligence period is only a time frame in which the buyer has the option to terminate the contract for any or no reason under no penalty. So in this example, what happens if a seller terminates? Can they? Yes, they can, and you now have a terminated contract. The issue is there are consequences to the seller for terminating. They are now in default of the contract. So now what happens? Now, as I always teach, we look to the contract as the instructions for what to do. So let me share my screen and let's see what the instructions say. So if you look, and I am using the GAR, Georgia Association of Realtors Purchase and Sale Agreement F201. And if we look under the default section, this is paragraph C2, default and remedies of buyer. In the event the agreement fails to close, so if it's terminated, it's not going to close due to a default of the seller. It is a seller default because they terminated during the due diligence period. I'm not going to the due diligence period, but that is solely a buyer's right to terminate with no penalty. If the seller terminates, they have now defaulted. So in the event the seller defaults, the buyer may either seek specific performance of this agreement, terminate the contract and get their earnest money back, and buyer may pursue any other remedy available under law. If a buyer seeks specific performance of this agreement, it goes to court. There will be a lawsuit. In the meantime, there is a notice that attaches to the title of this property, preventing the seller from selling the property to any other buyer. And a judge rules if the seller has to go forth and honor this contract or perform on this contract. That can take any amount of time depending on the county. Depending on how long it takes to for the attorneys to file the notices with court, so forth and so on. So it is a lawsuit, and it does prevent the seller from selling it to somebody else. Or the buyer may accept the termination or terminate themselves, get their earnest money back, go find another house. And the buyer may also pursue any other remedy available under at law, which a lot of times means a buyer will sue the seller for for damages or their out-of-pocket expenses. Additionally, under the default section, rights of the broker. The brokers involved in the transaction, both buyer's broker and seller's broker, have the right to enforce all provisions of this agreement and shall have all remedies at law or in equity available based on the breach. The defaulting party shall pay, as it goes on to say, as liquidated damages, compensation each broker would have received had the transaction closed. Additionally, if attorneys are hired, so in this example, the seller has defaulted. If the buyer hires an attorney, attorney's fees. The non-prevailing party in a lawsuit, meaning the loser, shall be liable to the prevailing party, meaning the winner, they would have to pay the winner's potentially reasonable attorney's fees and expenses. So, what does all of this mean? This means that, yes, unfortunately, at this point, you do have a terminated contract. There are a lot of financial and legal consequences to the seller, in my example, for this default because they terminated without a contractual right to do so. What do you do as the buyer's agent if you have a buyer who really wants this house? You are still negotiating through items during this due diligence period. Well, one of the options would be for the agents to be in touch with one another, point this out, seller's agent point this out to the seller so they understand that it's not simply giving the buyer back their earnest money and going on their merry way. There are severe legal and more expensive financial consequences to their legal default on the binding agreement. And perhaps the parties wish to reinstate the contract and go back, continue through the transaction and successfully close. So thank you guys so much for watching. Just a brief contract tip, and I hope it helped you out. Dana Sparks, broker of Maximum One Greater Atlanta, satisfying your needs with service, innovation, and education. Bye. If you like that video, check out the one here. If you like the content on this entire channel, please click here to subscribe. I try to take even the most complicated of real estate situations and make them crystal clear. See what I did there? Real estate made crystal clear. Thank you guys so much for watching.